Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
And I'm Kerry Fink with Helping Seniors Television. Welcome to today's program. I have the privilege of sitting in for Helping Seniors Television President and Founder Joe Steckler. And today we have a show that's going to be very interesting for you to learn about called Guardianship. And this is going to be a really interesting conversation because we've written down a lot of questions that we want to ask our expert. And in the house, I'm privileged to introduce you to Greg Schwendeman, who is part of the law office of Amy B. Van Fossen. And thank you for joining us. We were talking a little bit about this, and I really almost would think we might title this a primer on guardianship, because I want to ask you first to help us understand, what does guardianship mean? It's kind of a technical term, and somebody may run up on it for the first time, and we really don't understand what it means.
Guardianship is when the court appoints a surrogate to make the personal, financial, legal, and medical decisions for someone who no longer has capacity to do so. So in layman's terms, it's when the court lets someone step into the shoes of another person and make those decisions.
And what we find out is that that happens at a time when we're talking about seniors most often. Is that happening at a time when they're just not in a position to make a decision? Maybe their mental capacities have declined, or they're having a memory issue, or what do you find is a cases that lead to guardianship?
Usually in this area, that is exactly it. We have one of the oldest populations in the state and in the country, and so what we're finding is many times we have snowbirds. They were very healthy, very active when they retired and moved down to Florida from New York or Pennsylvania or wherever, and they left their family up there. So now fast forward, their faculties have declined and they need someone to help take care of them. And they don't have family around many times. So what happens is usually a sibling or a child will come down and start a guardianship proceeding where they will apply to be the guardian, or perhaps have a professional guardian step in that role if they're unable to do so.
You know, I was going to tell you anecdotally, as a charity here, the Helping Seniors organization, we get calls all the time on the Senior Information Helpline at 321-473-7770. Our number again for that helpline is 321-473-7770. And one of the things that we get calls a lot of time is just exactly what you refer to. Is we'll have calls from people who are saying, listen, I'm from, pick a state up north. I was down here visiting mom and dad during the holidays, and I'm really getting concerned that they're not able to take care of themselves, and I don't really know where to begin the process. And so you're saying that's oftentimes what happens with guardianship.
Yes.
Now, is that the place that you would normally begin if somebody were to call the law office and say, listen, here's where I am? Is that where you would start with a guardianship, or is there a conversation that's had to figure out, is that the best plan, or how does that work?
Exactly. What you want to do is find out, the court looks to see what are the least restrictive means, because a guardianship is a very powerful legal tool. It's taking away all of the rights from a person.
Right.
And so the court doesn't want to jump to that end result and take all of your rights without first seeing, is there a lesser means we can do? Right. So we have that conversation and we find out, well, did mom or dad perhaps have a durable power of attorney? Do they have a healthcare surrogate and living will? Do they have a pre-need naming of a guardian or a trust? And these are things that courts will look at and say, yes, with these, in most instances, you can avoid a guardianship.
Now, that was a question I was going to ask. So therefore, is a guardianship good for everyone?
No.
Okay.
And that's the case with most legal tools. It's a case-by-case basis. For some people, guardianship is an absolutely wonderful tool. It can help you as the child take care of your parent who now needs that guidance and care. But at the same time, guardianship is a double-edged sword, and it can be very dangerous in the wrong hands. So that's why you need to plan these things now while you are, while you have capacity and you can make the decisions. You can go to the lawyer and say, listen, I want to draft the door of a power of attorney and I want to name this person, so that you have that choice and you're trusting someone.
You know, we here, again, as a charity, we get a lot of calls from people who, you know, senior exploitation is a big thing that happens, where we get calls from people where somebody's involved. And one of the statistics I heard is oftentimes it's a family member who is the exploiter. And isn't one of the thoughts behind the guardianship is a way to kind of make sure that that situation isn't taking place?
Yes. Unfortunately, there were many instances of abuse in the past in Florida, simply because of the number of elderly we have here. And that is one of the things that the courts looked at and why they've changed so many of the laws recently. In fact, there was a case in Palm Beach County, I believe, where one of the judges was facilitating in this.
Wow.
And that made the headlines, and they looked at it. But yes, you have people, and sometimes they don't even realize they're taking advantage. It's just kids who think, well, you know, the inheritance is going to be mine and I'm helping out mom. But when you look at it in black and white, that money is necessary to help pay for the care, whether it's in-home or at an ALF. And so when you do the guardianship, one of the things that is required is that we have to provide an inventory and accounting. And those, the accounting has to be done every year thereafter on an annual basis. And that's one way the clerk of courts and the judge can keep an eye and make sure there isn't any wrongdoing going on.
So maybe a place to start, because I've often heard that guardianship pops into place oftentimes when somebody hasn't made a provision or expressed how they want things to move forward. So then the court is really left with no alternative but to create some legal vehicle to make that happen. What would be your advice to somebody as they start to consider their own path in aging? Because that's one of the things we talk about a lot, again, in helping seniors. Joe often talks about the need that we should all have an aging plan. And what he means is that if you think about it, when we're young and coming up and you're going to school or college and they're saying, well, okay, you're doing this, what is your plans for your career? And then even as you move forward in life, then say, well, what are your plans for retirement? How are you going to put this together while you're working, and how are you going to do these things? But then he goes, when we get to the part where we do retire, do we have an aging plan that plans for how we think things are going to go over the next 10, 20, 30 years as we think about retirement years? So if you're being proactive on that, where would you start with that thought as it pertains to guardianship?
I totally agree with that. I mean, we have plans for everything. We have hurricane plans.
Sure.
We, like you say, have retirement plans. And the plan you should have when you are getting up in age, depending on your own health, and that's a very big part of it, because some of the statistics are showing that dementia is now hitting people younger and younger. Okay, so what you need to do is think, well, if I get to the point where through dementia or some other infirmity I need guardianship, how am I going to avoid it? And that's where I said before, best way to avoid it is come in now to an attorney, an elder law attorney, while you are fully competent, have capacity where you can say, yes, when that time comes, my power of attorney will list who I want to be my agent. I want my son or my daughter. And you can put that person in your healthcare surrogate, the person you trust. And it's very important you put the person that you trust now in that role. That way, when the time comes, there won't be, hopefully, a need for guardianship. You can just go off of these least restrictive means.
Right. We had done a television program with Amy Van Fossen, who, as of course, is an attorney who specializes in helping people in those areas. And that was one of the things that she said she always prefers to see people come in before the fire happens.
Yes.
And I make this analogy, and I don't know if it's a good one, but I would assume that any good firefighter would much rather have you call them over to your house, to have them tell you about things like, well, this shouldn't be plugged in here, or you might want to store this farther away from that. They would rather come and tell you how to prevent the fire, although if they have to, they're going to be there to put it out, but it sure would be a lot less costly and a lot less troublesome if you were just ahead of that curve.
I agree. One of the things that's frustrating and sad is when someone will call us and they didn't do that. And they're calling us after the fire has started.
Right.
And they'll say, hey, I want to bring Dad in to have a power of attorney done.
Right.
And they're talking more and more, and Dr. So-and-so has said that Dad's got dementia, and you meet with Dad and he really is incapacitated. There's nothing we could do at that point because he doesn't have the legal capacity to sign the power of attorney. So at that time, it's too late. You have to do a guardianship, and that is expensive.
Well, that's what I was going to ask you. So this is where an ounce of prevention really could be worth a pound of cure, because by being ahead of it, once you've passed that point, there really isn't, there's no way to kind of go backwards with it.
Correct. Very, very rarely can you go backwards. I've had one case where it wasn't dementia and Alzheimer's, it was a different medical reason, and we were able to thankfully have this person recover to the point where the guardianship was no longer needed. Well, but that is rare.
Well, and that was a thing I was going to ask you about. The little bit that I understand about guardianship is that it is a process, and the idea is it's supposed to be the least restrictive process, so that once a guardian becomes involved, it's not necessarily that the person never has any ability to do anything ever again, but it's as long as that situation proceeds, I guess, or on the least restrictive, or explain that, how that works.
That's true. A person, and again, it depends upon the reason, but unfortunately, most of the time, the people we see, the ward, which is what you call the person who the guardianship will be set up for once they're at that point, they generally are coming into our office, their adult child usually, hey, I need to set this up, Dad's got dementia. Well, dementia is a progressive disease.
Right.
Usually we're not going to see them recover from that disease. So most of the time what happens is we sit down with them, we review, do you have these documents? If they do not have the documents, then we do take all the information that's necessary so that we could file the application for them to be a guardian, as well as the petition for guardianship. And then we have to go ahead and file those. Once we file those, then the court must appoint a 3-member examining committee. And again, looking at Florida's past, when people were using guardianships as a means to raid the bank account, this is a means that the legislature put in, so the 3-member examining committee will go out, visit with Dad, and find out, does he truly need a guardianship? Is he incapacitated? And they will file their reports with the court. The other thing that must happen, as soon as we file the petition, the judge must appoint an attorney and LSOR to represent the person you're seeking guardianship for. And again, that is for that person's protection, because remember, we're taking away all of their constitutional and, if you will, human rights, because once they're a guardian, they can't even decide on their own if they want an ice cream cone.
Wow.
That's up to the guardian to do that. So when they're in that guardianship, all those rights are gone.
Well, and that was a question that we had written down too, was, is guardianship only for the elderly?
No. Guardianship is for the elderly, of course, but it's also for minors if their parents have become incapacitated or are deceased, or if the minor receives, let's say, a settlement, insurance proceeds over the statutory limit, which is $15,000.
Okay. But typically, though, this was a question that was written down, and I wasn't even really familiar. It says, how many types of guardianship are there in Florida? And I didn't realize there was even you would distinguish that.
There's basically two types. We have a limited guardianship and a plenary guardianship. And plenary is sort of a legalese way of saying a full guardianship. So you have a limited and full. Limited, a person who has primarily a disability, but they can function in some areas, they can petition and have the judge appoint a guardian. We had one person who was blind, so they needed someone to help them with some aspects of their life due to that disability. The flip side is a full guardianship, which is called the plenary, and that is where the court will appoint a guardian to manage every aspect of their life.
So who can become a guardian? Let's say that maybe we did wait too long, and now mom or dad is definitely, as you would say, it's not possible for us to do anything to help mom or dad anymore because they can't make that decision. So we approach the guardianship question. Who can be a guardian?
There's basically three categories. Okay, the first category is you could say a family guardian, and that's many times what we see. The second category is a professional guardian, and the third category is a public guardian for those who are limited in finances. The family guardian is usually the adult child or a family member, but they cannot have a felony. That's the one caveat. Many times we will have a family member come to us to bring the issue of, well, dad's got this dementia, it seems to be growing, but I can't, for whatever reason, be the guardian, and then we'll introduce them or have the court appoint a professional guardian.
And if you, so actually at the end of the day then, who appoints the guardian? So let's say a person says, I think I could qualify or I would be willing to serve as guardian for mom or dad, but that's not automatic, right?
Correct. The only person who can appoint the guardian is the judge.
And so what then if a person, let's say that person, goes in front of the judge, makes the argument, I think I can take care of mom or dad in this case, so I'm willing to do that. So then what becomes the responsibilities for that person who is now the guardian? Say I'm going to be the family member who's the guardian of mom or dad.
Well, the family member has to take a brief course, and then that is a very good way to outline what they have to do in that course, and they must take that. But basically, what they have to do is look out for the best interest of the ward. And then they have to exercise the rights which that person would exercise on their own behalf prior to. And again, it has to be in their best interest. So in a typical scenario, they have to make sure that mom or dad are being taken care of for their physical health. Where are they? What kind of ALF are they in? Or are they at home? And what kind of parameters are set up for their safety if they're in the home? And that's something that we would have to prepare and file with the court. It's called a plan. The court needs to know the plan. And that has to be refiled every year on the anniversary date. And we have to let the court know, okay, the ward is being seen by this doctor. They're residing at this particular place, and here's how they're going to be safe, and here's the medical plan, and so forth.
So if a person says, listen, I'm willing to do this, I think I can help take care of mom or dad, would that often be a recommendation? Like somebody comes in the example you bring up, you said, well, maybe they bring in and say, well, listen, dad's having trouble with remembering these things. I need to do a power of attorney. So you're able to explain to them, say, well, that's not really an option for us at this point. So then we move into the guardianship I assume that's where you would take that discussion. You would say that's the only place we can go at this point.
That's correct.
How advisable is it for a family member to step in that role versus saying, let me suggest that we go for a professional guardian? I mean, how popular is either way?
There's no way to give a blanket answer other than to say case by case. Some people, when I meet with them, they may be so frazzled and so distraught for caring for dad already that to assume even more power, they're just looking to hand off to a professional guardian.
Right.
Other people know he's my dad and I'm going to take care of him, and that's it. You know? So it really goes case by case. And you have to look also, what are dads, we do have people who come to us and they want to take care of their parents, but they may not have the necessary skills to do so. And we might suggest maybe the best course of action is to have a professional do it.
And what happens in a case also, I would say, where you have multiple family members, and does it happen often that maybe they don't, maybe I should take care of mom or dad, or somebody else in the family says maybe I should do that?
That happens, and that's why I say please, please, please see an attorney while you have capacity, because the last thing you want is for your children to fight against each other over you as to who's best to take care of you, because that will, number one, turn all the siblings against each other. Number two, it'll wipe out your finances. It can be very, very expensive. If you go to an attorney to have the estate planning done, to drop the power of attorney, to drop the healthcare surrogate, I guarantee you those documents will be far less expensive than a contested guardianship.
So in the case, and I get that, so clearly advice piece number one is let's call the law office early and get these paperwork items pulled together while there's time, while mom or dad has capacity, etc. But what happens when somebody wanders in your office and says, well, I wish that was the case, but here's where we've arrived at. Mom or dad already has this problem, and to be honest, I have a difference of opinion with my sister or my brother about what should happen with dad. Because that also, unfortunately, is part of what sometimes you're having to be called in to try to find solutions in those environments.
Sometimes you won't have a happy ending. You just can't avoid it. And that's where you will have a contested guardianship, and the judge will listen to all the parties and make the decision as to whom should be the guardian. Sometimes you're able to say, okay, fine, you think you should be, and sister, you think you should be. How about if we have someone in the middle who is unbiased, and that's where you would look towards a professional guardian. Yes.
Now, we've had some stories in the news recently, fair or unfair, I don't even know, and I'm not even interested in the specifics, but would you say that that's common with professional guardians, that there would be a problem, or are they just, when you see these like sensational news stories, are they just sensational, I guess?
Well, I know which one you're referring to, but like any business, I don't care what the business is, you're going to have bad apples as well as some really great people. We are spoiled here in Brevard County because the legal community is, I think, it's a tight-knit community. It's a smaller community than, let's say, Orlando.
Sure.
And they're very easy to work with. It's a good working environment, and that ultimately helps the client or the ward. Okay, but when it comes to your basic question, though, you can have abuses by a guardian. You can have abuses by a family member who is the guardian, the professional or family. It doesn't matter. If a person is bad, they're going to be bad.
Yeah.
And when that happens, that a person is a bad guardian, you can go before the judge and petition to have that guardian removed, replaced.
Even if you're not necessarily a party to it, right?
Right, and that's the other thing. You don't, when you say not necessarily a party, let's jump back to the initiation of the guardianship. You don't need to be the son or daughter of the elderly person, in most cases. I'm referring to elderly because that's probably 90% of the cases out there. But what happens sometimes, and this is where some abuse can come in, you will find a worker at a ALF, an assisted living facility, may tip off a professional guardian that, hey, this person has some money, maybe you should be a guardian. We've seen that. Not so much now, but that's the sort of thing that if you do a little bit of research about guardianship prior to the changes in the law, that happen much more.
Wow. So it's a good thing. Well, we're about out of time on the show, but I wanted to make sure I asked you if you could give a phone number so that if people were wanting to get some more information, what's the best step that they would take? Who would they call? How would it move
Give
forward?
us a call at 321-345-5945. And we'll be happy to sit down with you and go through all the pros and cons. And you might find you don't need a guardianship.
Yeah.
But if you do, we'll tell you what is the best way to go.
Oh, that's good. The phone number one more time.
321-345-5945.
Greg Schwendeman, thank you for being here and talking with us about guardianship. I think we've learned a lot about things that we can and should do, and hopefully we're going to be able to be ahead of the curve and come and talk to you and get our paperwork together before we get there. But even if we've missed that moment, it still sounds like it's worthwhile, and we should give a call to really, if we're going to have to find ourselves working with a guardianship, it seems like it would be worthwhile to make that happen in the right way.
Absolutely.
So thank you for joining us today, and thank you, viewer, for joining us for Helping Seniors Television and being part of it. HelpingSeniorsofBrevard.org. Thanks.
Thank you for having me.
Joe Steckler, thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.